Testing, Judge Microphone 1. Testing, Judge Microphone 2. Okay. Testing, Judge Microphone 3. Testing, Judge Microphone 4. Testing, Judge Microphone 5. Testing, Judge Microphone 6. And testing, Judge Microphone 7. Testing appellee microphone. Appellee microphone. Beautiful. And appellant microphone. Testing appellant microphone. Judicial Force is a law court within the state of Maine, and will declare that it shall be heard.
Good morning, you can be seated. The matter before the court is Aroostook 25-177, State of Maine versus, is it Jayme Schnackenberg? And I see counsel are present, ready to proceed, I'm assuming. And if you would identify yourselves by saying your names for the record, starting with the appellant. Thank you. We are being streamed on the web, both by audio and by video. And Attorney Pratt, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you and good morning. Madam Chief Justice, associate members of the courts, if it may please the courts, self-defense was the only real issue at trial. Yet the court excluded toxicology evidence that corroborated the victims.
Well, I see that you left the green light on from the beginning. So the toxicology results, the fact that she had methamphetamine in her system came in, right?
By stipulation after the court, we believe, incorrectly ruled about excluding it. So the defense was put in a position where it really had no option but to agree to a stipulation in order to get it in.
Well, that's assuming the court was a final ruling. It did seem that it wasn't, that part of the ruling was that there hadn't been established a basis for putting it in yet. But I have a little bit different question. And that is, what I understand you wanted in, that you didn't get in, if you will, was some information that I believe was on the report that somebody who's using methamphetamine can exhibit violent and irrational behavior. Is that right?
That's correct.
Wasn't your client using methamphetamine? I mean, doesn't that cut both ways? How can that possibly be harmful, even if it's error?
Well, because we wanted it to come in because we believed it corroborated intoxication. We believe it would corroborate the testimony.
Well, you got the intoxication corroborated because you did get in that she had methamphetamine in her
No,
system.
I don't think we got in intoxication. We got in that she had it in her system, not necessarily that she was intoxicated or the effect that it would have on someone. All we had was that it was present in our system, which is different than intoxication.
But your client, by his own admission, was also using methamphetamine. I mean, and so doesn't this really cut both ways? I mean, how can it possibly be, even assuming it's error, in other words, not to have let that in? And let me just say, you didn't try to recall the person once you got it in. How can it possibly be a harmful error when it undercuts his theory just as much as it supports it?
I don't think it undercuts his theory. I think it supports his theory. And as the state during the trial, and I believe during the brief, I would describe it as incredulous in the description of my client's version of events. And the necessary corroboration of any element, even no matter how small it was, about the intoxication of the alleged victim and how that would support his reasonableness of fear, and it would explain his conduct during the altercation. We believe that it was a net positive. It
would explain his conduct as being violent and irrational?
I think that argument could be made, but from the defense's perspective, we thought it was absolutely necessary to have that information to support the version of events that Mr. Schnackenberg eventually testified to.
At the time the court excluded the evidence, the self-defense testimony hadn't been put on yet. It was in anticipation of that, a motion to allow it. He eventually did testify, and I'm wondering why, after he did testify in the entire factual scenario surrounding the potential defense of self-defense was then of record, that it was not renewed. Was it renewed at that point?
It was not. The defense believed, and I still believe after reviewing the transcript, that a final decision was made by the court. And I would ask this court to look at volume 3 of the trial transcripts, page 142, where the trial court says, all right, even if there was a showing that it was somehow related to the case, this is in regards to the toxicology report, how does what this doctor may opine related to general use of substances tie in with what this case or any reasonable belief of fear?
But Mr. Pratt, right after that, I'm looking at pages 44 and 45 of the appendix, which is what you're quoting from.
Yes.
Right after the court made that statement, defense counsel said that it would be permissible in the event that it is generated if Mr. Schnackenberg were to testify that she was using methamphetamine. So he acknowledged at that point that the self-defense issue that would provide the relevant foundation for the victim's use of methamphetamine hadn't yet been developed.
I think that the trial counsel at that point was indicating that he thought it should be able to be renewed after if Mr. Schnackenberg testified in the way that we anticipated him testifying. But I don't think that that removes the fact that it was a final ruling from the court earlier.
Can I focus you on that for a moment?
Yes.
The court's ultimate ruling on the issue was that it's not appropriate to admit on a conditional basis, because that's what trial counsel was attempting to do there, was to, well, let's just admit it and then we'll connect up later. The court ultimately said, well, I'm not going to do that on a conditional basis. That's not a final preclusive ruling, is it?
I think that the quote that I was reading from suggests that it was a final ruling.
Well, I'm reading from a quote that's a couple of lines after that. And where the court says, and so the court is not convinced that it's appropriate to take the testimony on a conditional basis.
I think he says that as well, but I think both things can be equally true. One, he doesn't believe it being allowed to be conditionally admitted would be appropriate, and second, that it was a final ruling. But if I could go back to the idea of whether it would be appropriate or not for a conditional ruling, as this court well knows, that the defense has the right to present a defense. And we believe that the right to present a defense should include the testimony about the toxicology report. But within that, there also should be some allowance for the defense to decide how that defense will be presented chronologically. There's a narrative arc when defense attorneys are presenting their case. It's not just getting all the information in any sort of random order, but there's a narrative style to it in order to culminate to have the greatest possible impact.
So you're saying the ruling would have made a decision possible on how to present the defense if you had that conditional admission up front? Is that what you're saying?
Yes, because then this information could have come in.
My following question is, because that didn't happen and because he did testify and apparently a decision was made not to recall the expert, so that was a strategic decision after the testimony?
Well, I think that I think that at the time, because I was one of the trial counsel, I was one of the three, so I can say this, that I believe that we thought there was a final ruling by the courts.
Oh, okay.
Maybe, and from the quotes that we indicated that we thought it was a final ruling.
But yet counsel,
decision not to call him.
but yet counsel, there was a specific request to excuse the medical examiner finally, and trial counsel said, no, we'd like to keep him around, essentially. So the medical examiner was still available. The expert was still available to be recalled as part of the defense case.
So we were put in a bind where we felt we had no choice but to agree to the stipulation, which would alleviate the need for the state to recall the medical examiner, which then also created a situation where we then got the state to stipulate to the existence of the methamphetamines in the alleged victim. And because of that, we thought that there was not a benefit to recalling Dr. Fuente at that time, because we had no belief that we were going to get additional information from Dr. Fuente based on the final ruling that we thought the judge had created, and that was our only option.
Sorry, go ahead.
Is there something in the record that would establish that Dr. Fuente would have been qualified to talk about the effects of methamphetamine or to get into the quantitative information about the amount of methamphetamine that was found in the victim's system? He's a pathologist. He's not a toxicologist.
No, I was trying to recall because I didn't want to misstate anything. My recollection, and I'd have to double check the transcript, is there was a discussion about the quantity of it and that he would be able to testify to that based on the report.
That was a report from Pennsylvania.
Yes.
So the question, there would be some questions about the admissibility of that information through Dr. Fuente.
Certainly, that's why the trial court said no.
Right, but aside from that, I mean, would Dr. Fuente have been able to, would he be qualified as a pathologist to talk about the sort of the behavioral effects of use or ingestion of methamphetamines?
We were certainly going to try, and we had the belief that based on prior experiences that he would be able to do
Is there
so.
something in the record that would
No.
establish that you would have been able to get that evidence in any way?
To the best of my recollection, I'm fairly confident in this. I would say no to that question.
Can I redirect you to the, one of the other issues here? Precisely what is it that you think is defective in the court's self-defense instruction?
It's specifically in regards to the, okay.
Is
It's
it the placement, or
structural-
is there an error?
No, it's the structural, it's the structure of the jury instructions itself. We are in no way saying that there's anything in it that is legally incorrect. However, this court in the past has said there has to be a clear and understandable framework. I think the specific language you have used in the past was roadmap in order to, for the jury to find a not guilty verdict. It is our opinion that the placement of the discussion of the dwelling exception, or otherwise, as I refer to it as the retreat requirement or lack of retreat requirement inside one's home, the integration of that was ambiguous and unclear, and that the jury could think that the retreat was required inside the home.
Where would you have put it? I mean, as it was structured, the court went through the sequence of, I'm going to instruct you on murder, I'm going to instruct you on manslaughter, I'm going to instruct you on self-defense. And it was in the self-defense instruction that the court referenced this dwelling place exception to the duty to retreat. Are you saying that the court should have repeated that again?
Essentially, yes.
Where?
So I can say specifically at trial transcript volume 5, pages 94 to 95, when the court is going through all of the different, basically says there are 4 things that the state has to prove, and goes 1, 2, 3, 4. It should have been during that time, specifically after point 4, where that should have been reiterated, because it was previous.
Sorry, where in the record is that?
I apologize for talking so quickly.
Appendix 82, 83.
Thank you.
Oh, that would probably have been the better way to cite it. Thank you, Your Honor.
It's what we bring with us onto the bench.
Yes.
But the court did say, I mean, at the bottom of page 82 of the appendix, when the court is sort of talking in the abstract about the 4 points, and then on the next page of the appendix, page 83, sort of in the middle of that page, the court reiterates point number 4, which is the dwelling place exception to the duty to retreat, and then appendix page 85, starting at lines, going through lines 9 through 12, that's when the court describes the roadmap. That was a term we used in Baker. That's when the court says if the court has failed to meet its burden of proving, self-defense, as I've already discussed with you, then it's a not guilty verdict.
And so I completely agree that it's said in the instructions about this no duty to retreat. Again, the problem for us is the placement of it, and not specifically when going through the 4 things that the state needs to prove. We believe that that is a structural defect.
Counsel, let me ask you about the preservation of this argument about the placement. I see that you flagged some confusion for the court when the court was working on the jury instructions. And then, as I understand it, the court did make some modifications, maybe not exactly what you wanted, but did make some, and then invited the parties after giving the instructions to say, are there any other objections? And none were made.
Right,
So
and I would
is this preserved?
I would say yes, because I thought I made it as absolutely explicit as possible that we were objecting to the structure. The court essentially tinkered with the instruction but made no significant changes, so that when it came back onto the bench and asked for are there any additional objections, we took that to mean any objections that hadn't been previously articulated. I think that is the only fair way to interpret that. And
Finish your sentence.
So we think that the argument was clearly preserved. Thank you.
Thank you. Attorney Robin?
Madam Chief Justice, Associate Justices, may it please the court. The evidence at trial compelled the conclusion that Jayme Schnackenberg committed the ultimate act of domestic violence by shooting Kim Hardy, his long-term live-in girlfriend, twice in the back of the head because she was leaving him and taking the cat, and then concealing his crime in his futile attempt to clean her blood from the kitchen, wrapping her lifeless body in layers of tarp and garbage bags held together with duct tape prior to dumping it off on a remote logging road. On appeal, you've heard Mr. Schnackenberg has some quibbles with 2 evidentiary rulings, the jury instructions and the sentencing analysis. None of his claims have merit. He complains that the trial court excluded Kim's toxicology results, that she had meth in her system, when in fact those results came in by stipulation. He then complains that the court erred in not admitting the entire toxicology report with an explanation of the results, even though he did not proffer the author of that report to testify. Contrary to Mr. Schnackenberg's contention, the rules of evidence do in fact apply to the defendant, and State v. Mitchell does not hold otherwise. He next argues that the trial court should have excluded photographs of 2 of the bullet defects to the back of Kim Hardy's skull, even though those photos depicted how the skull fragment from Schnackenberg's mop fit neatly into the bullet defect and sutures from Kim's skull. The photos were indeed prejudicial, but not unduly so. There was no error in admitting them to illustrate the expert's testimony. You've also talked about the jury instructions. He complains that the jury instructions on self-defense, a theory that he presented only to his lawyer before taking the stand at trial. He asserts that the phrase explaining that a person is justified in not retreating from the encounter, quote, if that person is in the person's dwelling place and was not the initial aggressor, close quote, should be next to the 4th element of what the state must show to disprove self-defense beyond a reasonable doubt, quote, that Mr. Schnackenberg was the initial aggressor in his own dwelling, and he failed to retreat from the encounter with Ms. Hardy, despite the fact that he knew that he could do so with complete safety, close quote. As Attorney Pratt has indicated, there's no allegations that the instructions are missing any element. Indeed, these 2 statements basically describe the failure to retreat in one's dwelling from different perspectives. When a person is justified in not retreating, and what the state needs to prove beyond a reasonable doubt to prove that the failure to retreat was not justified. The 2 statements also appear on the same page as the written instructions, with the element that the defense sought to emphasize, that a person is not required to retreat in his dwelling place if he was not the initial aggressor, set out from the rest of the written instructions in italics. Mr. Schnackenberg really has nothing to complain about with the jury instructions. Finally, he raises the consideration of domestic violence at each step of the sentencing analysis, and we contend it does not amount to double counting. The court below reviewed the domestic violence aspect for different considerations at each step of the analysis. In step 1, it was applied to the nature of the crime so that his conduct could be compared with other domestic violence homicides. Yes. Yes.
Quickly about the photographs.
Yes.
Do you agree that the photographs have probative value and also prejudicial effect?
Yes.
Okay.
Not unduly, but the probative value outweighed the prejudice, and it was not unduly prejudicial. In fact, I mean, it was key to the expert's testimony.
And we have a history of allowing photographs, goes back decades.
Yes.
And I'll raise the issue briefly before we move on to other points, but the state's motivation putting the photographs in, I mean, we know that it isn't really a secret here that she died from a bullet passing through her brain. So it has probative value, but it isn't a critical bit of the state's evidence. But our jurors they're not forensic professionals. We've seen these photographs before. They don't have, but some of them, it's going to whack them in the gut to see these things up close and personal, and it introduces an emotional factor into the proceedings. And I'll just ask you point blank, is the state aware of the fact that it will have an emotional effect, and that doesn't hurt the state's case to put it in for that reason?
We did ask in the jury questionnaire whether anybody had problems with gory photos. I mean, we've had some issues in the past with jurors having an emotional reaction, and sometimes, especially in depraved indifference murders of young children, they are very emotional, but they're necessary. And in this case, we started with the theory. Recall that there was no evidence of self-defense generated in this investigation. Mr. Schnackenberg repeatedly told people, Kim Hardy walked out of the door. She was alive. Don't know why she didn't take her car, her phone, or her bank cards, but she was alive when she left here. And he was also trying to deflect blame to his drug dealers, the Vries brothers. So we had to prove that homicide occurred in that house. And one of the key pieces of evidence was the mop from his downstairs, his stairs down to his basement that tested positive, presumptive positive for blood in the field. And then when the forensic chemist was pulling it out to look at it, boom, the bone falls out. What compelling evidence that was
So why do you need the photographs?
because it shows that it wasn't an unrelated bone. He I think at one point may have said, oh, it could have come from, I cleaned deer in the house. This shows that it was clearly part of Kim Hardy's skull and that he attempted to clean up his murder of his longtime
I'll just ask you
girlfriend.
one more time, then I'll leave. the
Yeah,
topic.
yeah.
You have an expert testifying, this piece fits into this hole here, this came from the skull. The expert testified, and then you're going to ask, as the jury said, take a look at the picture and see if that fragment fits into that hole. You've already had an expert testify to it. What does that add to what the evidence is?
Well, as Attorney Pratt said in his brief, a picture is worth 1,000 words, and that photo helped to illustrate this expert's testimony, and she would point it out to the jury repeatedly. See how it fits right there. There's the suture. There's the hole. Fits right in there. And you know, we have the burden of proving it beyond a reasonable doubt. Should we just go with the expert giving a narrative when we have a photo that has compelling evidence that what she
With respect
says
to the
is
two
correct?
black and white photographs, you did have an alternative, which would be the x-rays. Why not just use the x-rays instead of a photograph of a dead person's skull?
She did not use the X-ray to do the placement. She used the
No, I'm not talking about the color photograph that Dr. Sorg used.
Yeah.
I'm talking about the two black and whites.
Yeah.
Showing the 2 entrance and 1 exit wounds.
right.
So why not just use x-rays to show the same thing instead of something that's much more graphic, which would be the photographs? And I appreciate that you scaled it down from color to black and white. But was the black and white even necessary when you had Plan B or Plan C, which would be the x-rays?
The photograph showed the bullet defect before Dr. Sorg superimposed the fragment over it. I think it's important to see what it looked like before and what it looked like after. I don't think that the X-ray would have done the trick. We did not focus on the X-ray. We made a choice to put in the photos of the skull, and I think it was Justice Nelson who said, yeah, I want the black and white, not the color.
Would the x-rays have shown clearly an entrance and an exit?
I did not review the X-rays in preparation for today. I don't know what they would have shown. Sometimes they are not. I just don't recall what they showed.
What's your position on the preservation issue that Justice Lopez raised?
On the self-defense?
Yes.
Yes. Our view is that it was waived because it appeared that just in reading the brief, Mr. Schnackenberg's brief, I really thought that Mr. Schnackenberg got everything he wanted with the self-defense instructions and with the toxicology results. And I think that the judge might have had the same impression because it was at a point where these two instructions, the two dwelling place references, were on different pages of the written jury instructions. He put them on the same page because of the complaint that they were buried in the jury instructions, not easily seen by the jury.
So you're saying there was a substantive change in moving up the instructions with respect to the dwelling?
That's right. Moving it in terms of on the same page and putting it in italics so that it is the phrase that pops out to the jury if they're going through those written jury instructions. And they had those written jury instructions in the jury room.
On the sentencing, the double counting argument, would you agree first that the court did reference the same fact that she was trying to leave with the cat at steps 1 and step 2 of the analysis?
That's correct, yes, Your Honor.
And so I know you've made an argument that they were used for different purposes.
Right.
When I read the transcript, it's a bit ambiguous what the court was doing with it with regard to step 2. What do we do with that ambiguity when we're trying to determine if there was improper double counting?
Well, first, I disagree that it was ambiguous. He specifically said, quote, if he would have simply let her leave, she and Mr. Schnackenberg simply would have gone on living their separate lives. The family and the community would not have been deprived of her presence, her friendship, her talents, and her contributions. He's using that fact directly to talk about the victim impact, a victim impact which was compelling at the time of sentencing. The courtroom was packed with family and friends of Kim Hardy.
Well, Certainly, I can understand the argument that the victim impact was compelling, but the reasons that she's not there still pertain to sort of the nature and circumstances of the offense. In other words, it doesn't really matter in terms of assessing the impact on the victim why Mr. Schnackenberg did or did not, shoot her. So I still am struggling as to why that's not really improper double counting.
Again, it's for a different purpose. It's for the victim impact as opposed to looking at the nature of the crime and comparing it to other domestic violence homicides on the continuum.
I think the point is the victim impact doesn't have to do with why he shot her necessarily. It's the fact that she was deprived, as the judge goes on to say, that the community, that her family was deprived of her comfort and her company for the rest of her life, or what should have been the rest of her life. And that is not dependent on why he shot her or
Well, it goes to the senseless reason that he shot her. The senseless reason. It was true. I mean, she's leaving and taking the cat. And so he is taking away this valuable person.
Step one analysis.
I think it's appropriate for step two as well. And I don't think personally that, I don't think even if it were considered double counting, it would have any effect on this sentence. The evidence was overwhelming what this guy did. As Justice Nelson said, he just has cold water, ice water running through his veins. What he did in this case is just...
You seem to be saying harmless error, but we've also said that if a judge says, I'm relying on this factor, we have to take them at their word. I mean, we didn't say, well, we could have reached the same sentence anyway.
I think that, I don't think it's a good use of this court's time, actually, to micromanage that kind of tweaking, because we are not talking about federal sentencing guidelines, which have numerical values and make a difference.
Well, it's not tweaking. If a judge relies on an improper factor, and I understand your argument that he didn't in this case, but if a judge relies on it, explicitly relies on an improper factor, I'm going to suggest to you it's not tweaking when we recognize that on appeal.
I think if you look at most of the sentences that you have remanded based upon your criticism of the Huey analysis in terms of homicide cases, just in homicide cases, that the sentences have remained the same on remand. And that's because we don't have a numerical system like the federal sentencing guidelines. We are talking about trying to articulate why we're reaching a certain number.
Well, and that goes back to my question about if there's some ambiguity about what the court was doing or trying to do, do we defer and give the sentencing court the benefit of the doubt? Which way does the ambiguity cut?
I think it would always be to defer to the trial judge.
We're looking at this, they didn't object at the time, right? To
no.
that issue. So we're looking at this under obvious error, right?
I guess it would be obvious error, yes. There's no objection to the sentencing court's analysis at that point, although I don't think I've ever heard an objection during a Huey analysis.
But we've said over and over that it's an obvious error if you don't object at the sentencing. So it's a kind of a different analysis when we're viewing anything that we might think is ambiguous.
Can I ask you just an academic question before your time runs out? In step one, we look at the four corners of the incident itself, and then in step two, we look at the factors that are unique to the defendant. Motivation, senselessness of the crime, those two categories, would a perpetrator's motivation be appropriate to consider under step one or step two?
Well, there's the ambiguity in the Huey analysis. It might, again, depending on what the purpose is in terms of the analysis, what consideration it goes to.
Right,
it might be appropriate for both levels.
That would be my next question. Is it really appropriate to consider in both step one and step two a perpetrator's motivation? Wouldn't that be literally double counting?
If it goes to different considerations in the Huey analysis, it would be appropriate. If there are any further questions, I'll sit down. Thank you.
15 seconds to spare. Attorney Pratt, can I ask a question I wanted to ask earlier, returning to the toxicology? I just want to clarify one point. Is the objection in this case, is the error that you're asserting the court made in excluding testimony of the doctor about the toxicology report and the ability to examine that doctor about the effects that would have, or is the error the admission of the report itself, or is it both?
It's both.
Okay, so why would the report actually be admissible?
All right, I take that back. It's the report through the testimony of the medical
The report
examiner.
informs the testimony.
Yes, that's the
Okay.
way I should have articulated it that way. But the contents of the report should have been allowed to come in through the medical examiner's testimony.
But you're really talking about an error in restricting the examination of the witness
Yes.
versus an exhibit coming in.
Correct.
I just
Yeah,
wanted to
yes.
clarify. Thank you.
If I could disagree respectfully with something that Justice Connor suggested, which is that the standard of review would be an abuse of discretion, I would suggest on a double...
Obvious error.
Are
I'm
you
sorry,
talking about
obvious error. Sorry.
Sentencing, you mean?
Yeah.
It would be for a reviews of double claim. A double counting claim is a de novo review based on this court's case law in Plummer and in Schlossler, if I'm pronouncing that correctly. I've cited to it in my brief on page 43. I would also suggest in this instance that while we concede that a fact can be used for two different purposes, as this court has said numerous times, in the Huey analysis, both on step 1 and step 2, it cannot be used for the same purpose in double counting. Here we would suggest the description by the trial court judge in regards to the cat in step 1, which we believe was subjective information, and step 2 was also subjective, while count 1 is historically reserved for objective and evaluation. So we believe that the double counting is clear. And also to answer Justice Lopez's question, if there is an ambiguity as to what a court's using a particular fact for, we believe that that's under, and may I just finish the one thought?
Of course.
That should be leaned in favor of the defendant, given concepts of the rules of lenity, given the concepts of what is at stake. So we would ask the court to resolve any ambiguity in favor of the defendant in that situation. Thank you.
Thank you, counsel. Thank you for the argument here this morning. As is our usual practice, we will be taking this matter under advisement, issuing a written decision in due course, and with that, we'll be in recess on this matter.
All rise.
Good morning, you can be seated. Before the court is Kennebec 25-359 regarding the child of Mindy. I see counsel are present. I'm assuming you're ready to proceed. We are being streamed on the web both by audio and by video. If counsel would identify yourselves by saying your names for the record together with your party you represent, starting with the appellant.
Good morning. My name is Taylor Kilgore. I represent the appellant mother, Mindy.
Good morning, AAG Hunter Umphrey for DHHS.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you. May it please the court, on August 31st, 2023, with no motion filed, no notice to Mindy, and Mindy not even present, 3 attorneys met privately with a judge. No testimony was taken, no clinical evidence was offered. Only her own attorney, in breach of privilege, called his client difficult and dysregulated. And that was enough. The court stripped Mindy of her legal autonomy entirely. In 7 minutes and 49 seconds, Mindy lost the right to direct her own legal representation and ultimately the right to be a mother to her daughter. The consequences culminated in a guardian ad litem consenting to the termination of Mindy's parental rights without ever discussing it with her, while Mindy protested at every turn. But this case is about more than just Mindy. This court has never addressed 2 questions arising in courtrooms across Maine every day. First, what process is due to a parent before they are declared incompetent under Rule 17b? Must there be a motion, notice, an opportunity to be heard, some sort of clinical evidence? Based on what happened to Mindy, the answer appears to be none of the above. Second, once appointed, what authority does a 17b guardian ad litem actually have? And more importantly, what authority do they not have? Without answers to those questions, a declaration of incompetency in a child protective proceeding is its own civil death penalty, imposed in under 8 minutes, without a hearing, and no way back. We ask this court to vacate the termination order and establish guardrails that Mindy and every parent who comes after her deserves.
So I see the green light is on. Is the remedy, what does the mandate in this case say from your perspective? Assume we agree with you that that process is not adequate. What does the mandate say?
That this court needs to vacate the termination order, the guardian ad litem appointment, and every order that that guardian ad litem agreed to over Mindy's objection, which is every order in this case, Your Honor. There was never testimony taken, there was never evidence, there was never any findings made independently
through counsel,
by an important fact.
through her own attorney, not the guardian ad litem, but through her own attorney, she agreed to the judicial review order from March 27, 2025. So why does the case have to be unwound past that?
So the case has to be unwound past that, Your Honor, because due process was required, and it was never provided to Mindy. But more basically, I don't know that we actually know that Mindy agreed to that March order. The only people present in
her
the court-
attorney said that she did.
Her attorney said we did, and she only spoke of herself and the 17b guardian, who were the only 2 people present that day.
What if we sent it back and the proceedings start with an incompetence hearing, a real one, with medical records, and everybody gets due process, and the conclusion of the judge, supported by the evidence, said, I find that she was incompetent and that she was incompetent throughout these proceedings. Then can't we just allow that? Then what's wrong with the guardian having agreed to consent to the termination?
The guardian can't consent to termination.
After ever?
No.
Even if the
What's your
person
authority for
thinks
that?
they're a banana and they are incapable of articulating anything, you think they have to go through a termination proceeding on the merits?
Absolutely, Your Honor. I believe that the department needs to be held to their burden, and that's what due process requires. But also, the entire idea here is that Mindy gets to direct her own
But the
representation.
premise of the question was she is incompetent to do so, that she cannot assume the facts. And I understand you don't think the facts support that here.
Yep.
But assume a case where somebody truly is incompetent.
Sure.
Maybe they are in a coma, maybe whatever.
Sure.
Are you saying that the guardian in that case cannot ever consent?
Under the termination statute, they can't. Only a parent can consent to the termination of their parental rights.
But if you're appointing a guardian for someone who's incompetent, the idea is that they stand in the shoes of that person. They sort of take on their decision-making authority. Isn't that the idea?
That's not really what the case law says. The case law says that...
What case law are you talking about?
So Petrolic, I'm not sure that I'm saying that correctly, but it says that they can't concede their client's rights. First and foremost, the right of my client that was on trial in that entire proceeding was her right to be a parent and her right to due process. And neither one of those things were protected when a 17B completely gives up her right to parent and her right to due process.
So you're saying that a GAL can never concede anything? That if they step into the shoes of the person who's been found to be incompetent, they basically have to fight, oppose every action that the department wishes to take in one of these cases?
Yes, because while we all operate, and I have in fact as well, in these cases of no, a 17B GAL stands in the shoes of, I certainly can't find the authority for that. There is no talk of best interest in the rule or in any of the case law.
So what is the guardian's role then if it's not the best interest of the ward?
I'm not sure. That's what the guidance is that is required from this court, to be honest, Your Honor.
But
17B.
doesn't this case turn on that? I mean, if the guardian is making a decision that the guardian feels is in the strategic best interest, saying there's two ways this can go, this one is terrible and this one at least will preserve some things, as the guardian, I'm going to make this decision. But you're saying the guardian can't do that even with a ward who's incompetent?
So I also don't think that 17B requires a guardian ad litem when the client is already represented. The very language of the Rule 17B says when not otherwise represented, a guardian ad litem has
if
to be
the attorney says, okay, there's two paths we can take, one is going to be a big mistake, this one is much better, I'm going to go ahead and take this one.
I would argue, Your Honor, that my clients who are competent make decisions on a daily basis that aren't always in their best interest.
Let's say an incompetent client been declared incompetent. The attorney looks at a couple of options and says, my fiduciary duty to this client is to do what's in their best interest. They can forge ahead with this, and it's going to be a disaster. We can get this kind of middling kind of agreement here that'll status quo. We're going to go for that. The attorney can't do that?
We're not supposed to, ethically, Your Honor, we can't substitute our own judgment for our clients.
And that's why you need a guardian who can substitute.
I can't find the authority to tell me that that's exactly what they can do.
Well, there's lots of authority. I'm going to just suggest to you, there's lots of authority out there, particularly from other states, that talk about that when the guardian is necessary, the guardian is authorized to act on behalf of the ward, making all appropriate decisions, including settling any claims, et cetera. So.
Again, Your Honor, the Maine case law says that they can't bargain away a right of the client.
I'd like to take exception with one thing you said in your opening, which was that the attorney number one violated his privilege by raising this issue. We have said in Mercedes D, for example, that the attorney should raise the issue with the court when he thinks that there's a competency issue. So there was no violation at that point, was there?
I think that's up for debate, Your Honor. What is said is that the attorney needs to flag a concern for the court. That attorney simply could have walked in the room and said, I have a concern that my client may be incompetent. And
so
that's where
he's not allowed to explain why he thinks that?
I don't think he can. He has a duty to his client.
Well, then why in Mercedes D did we deny it, saying the court denied it after he asked what the reason was, and we found, based on that evidence, that they didn't need to have an incompetency, find her incompetent, because the attorney's representations were not sufficient to show that there was incompetency.
And that's exactly the point here, is that his representations never met the burden, the evidentiary burden, to declare Mindy.
Yes, but they looked at what the attorney was saying. Doesn't the attorney have to, he can't just go in and say, oh, think she's incompetent.
Can't tell you why.
Again, the duty is to raise the concern. Going beyond that works against his client. His job is to follow his client's lawful directives, which his client didn't give him.
What if they can't give lawful directives?
I mean, isn't that the catch-22? You keep saying that they have to do what the client wants, et cetera, et cetera. But the point, and I understand you're not conceding that your client in this case needed a guardian or was incompetent. But when someone is incompetent and incapacitated, that's the whole point, is they can't make those decisions, so you can't follow them as the attorney.
And maybe in those very few circumstances where someone is actually in a coma, Your Honor, and can't communicate at all what their wishes are.
Well, let me suggest to you that incompetence is a lesser standard than that.
I believe that, Your Honor, but in this case in particular, when we don't even have due process to start with to know whether or not this client is competent, we can't make any of these assumptions.
And I understand that argument, and that's why we keep trying to separate them. We all understand the argument you're making about the process that was employed here.
Yes.
And the determination as to whether somebody was incompetent. That's one issue. But then there are the other issues. You're saying even if the person is incompetent, it would be impossible for the guardian to consent. I think that's where we're sort of...
And for that alone, Your Honor, I come back around to the statute in Title 22. It says a parent can choose to consent.
So again, I think the Chief asked you at the outset, what would you say the mandate would be? And Justice Jayme asked you, how far do we have to rewind this thing? And you said to the start, and the mandate is everything wipes the slate clean. So let's say there is a competency hearing.
Yep.
And your client is declared to be incompetent.
Yes.
Why, at that point, what happens? Can we just reinvigorate what happened previously, or does it require the guardian ad litem to say again, we agree to this thing because it's a better choice than the two going forward? What happens then? Because you want us, and probably everyone else will want us to offer some guidance on that issue.
Oh, no, I'd love for you to offer guidance. I think under Petrolik, the idea is that the department needs to meet their burden. That's what due process requires. The guardian can't give up those rights along the way. That what the guardian has to do is protect that right to due process and that right to the department meeting their evidentiary burden.
So
Did the department meet its burden at the Jeopardy hearing?
The Jeopardy hearing never finished. So there's no way of knowing, because no impartial fact finder ever found any facts in this case.
And was that the reason why the guardian felt that it would be best to do the agreement so there's no finding of jeopardy? It wasn't clear to me what the path was, why that's a better decision than forging ahead.
I'm not sure, Your Honor.
All right.
Can I ask you a court process question? My review of the docket records indicate that there were 10 different district court judges who were involved in this case, some more than others. In your experience, is that pretty typical?
It might be slightly more severe than some, but it is not atypical.
Thank you.
Thank you.
May it please the court. This is a case about a child who entered state custody at age 2 in June of 2023. Several months later, in September of 2023, the mother was involuntarily committed after experiencing psychosis. The district court appointed her a guardian ad litem, a fiduciary, under Maine Rule of Civil Procedure 17B that month. At the mother's request, that guardian ad litem negotiated a jeopardy agreement for her in May of 2024. There was an evidentiary hearing happening when guardian ad litem Hatch, at the mother's request, negotiated that agreement. The mother was present along with her court-appointed attorney, an attorney she had retained, and her guardian ad litem when her jeopardy agreement was put on the record. Judge Dufour invited the mother to address the court directly, repeatedly, but the mother declined. Judge Dufour also explained to the mother that she would have further opportunities in this unitary proceeding to address the court at future hearings. Now, The mother struggled during the reunification effort. She did not reliably take her psychiatric medication. She did not reliably participate in rehabilitation services, and she did not reliably visit with the child. And some of the contact that they did have was upsetting to the child. Despite having been served, the mother failed to appear at the termination hearing in August of 2025. That constitutes abandonment under the statutory framework. The department was prepared to present evidence, but the mother's representatives persuaded Judge Dietrich to accept a consent on the mother's behalf. They were shielding her from two aggravating factors, not only abandonment, which I mentioned, but also the involuntary termination of parental rights. The mother has never explained why she failed to appear. I heard the phrase protested at every turn, and that caught my ear, because the mother has never moved to reopen the evidence, moved for a new trial, moved for relief from judgment. This is a discussion today that's focused on Maine Rule of Procedure 17B. I think today's case is actually more in the lineage of cases like In Re AM, where we're talking about what process is due a parent who's been served but isn't present for a termination hearing. I think this case is more in the lineage of In Re Robert S. out of York County in the late 2000s, where a parent had been served and didn't appear for the hearing. No one even tried to present any evidence, and there was an automatic termination, a true default, a true civil default occurred and was sent back. The department was cognizant, you can tell from the transcript, of a precedent like that when the Assistant Attorney General at trial tried to present evidence and wasn't able to. Our position is that the judgment under appeal should be affirmed. Our position is that affirming that judgment would advance the important interest in delivering children to permanency in a reasonable time.
I see that the green light is on in your opening statement here, and I would suggest in your brief as well. You haven't really commented on the process that was used to appoint the 17B guardian. You've suggested other reasons why we should affirm anyway. But is it the state's position that the process used to appoint the 17B guardian in this case was adequate?
It was certainly not ideal. I have thoughts on how to improve that process. I also want to make sure...
There was no motion, there was no evidentiary hearing. Do you think there has to be at least some kind? I'm not saying it needs to be a full-blown trial, but some kind of actual evidence?
Hallmarks of due process are notice and an opportunity to be heard. I'm not comfortable reading the August 2023 transcript with the inference you can draw from it that not full notice or opportunity to be heard.
There isn't any evidence of notice, is there, to her?
We haven't had an opportunity to delve into that. What I want to say is this.
Nothing in this record indicates that there was notice to her, correct?
That wasn't litigated. What I want to say is this.
Well, when you say it wasn't litigated, there's a record. There's nothing in the record that indicates she was given notice, correct?
Very little from the record is known about that August 2023 court appearance.
It sounded like it was a spontaneous conference among with the judge and the attorneys because the case was on the trial list for the next week, for the following week.
What it sounds like to me is that that attorney was probably mindful of what this court said in Mercedes, what this court has said in criminal cases as well about counsel's duty to alert the court if there's an issue like that, but also mindful of some of the concerns Attorney Kilgore is highlighting this morning. You as the attorney with an obligation to your client wouldn't want to make too much of a record about exactly what you're dealing with. So
But isn't the point then that you have to have a hearing? I mean, it's one thing to, first of all, there's no written motion, but also assuming it, and I don't disagree with you that there's an obligation to alert the court if you think there's a competency question. Mike, we're good so far. What happens then? Is it okay for the court to simply appoint a guardian based on no actual evidence other than a representation of an attorney that I think she might need one?
Everyone deserves the opportunity to be heard. She had it at the Jeopardy hearing. That's where I was trying to get. Judge Dufour had the mother in front of her and repeatedly invited the mother to let the court know if there was anything she needed to say. The August 2020...
That wasn't a competency issue, right? That was, do you want to, agree with this, do you agree with what the GAL has done regarding Jeopardy in this case? She was never invited to challenge the GAL appointment, was she?
What we know she did is that she directed that GAL to take actions on her behalf, such as negotiate that jeopardy order on her behalf, short-circuiting the jeopardy
Did anybody
hearing.
ever explain to her, GAL has been appointed, that person now has, under the order, all of your decision-making authority. Perhaps we should give you an opportunity to challenge that, or at least take some evidence regarding whether this is necessary. That conversation never happened. Would you agree with that?
Not in the transcript I read.
So
It didn't
there's
happen in
nothing
the
in the record
transcript.
that we can draw on to determine that that happened?
I think that's true. Here's the difficulty I'm having. This is civil litigation. We're talking about a hearing that occurred several years ago prior to a court hearing that resulted in an appealable order. And not only did no appeal arise out of that order that issued, that order was issued after the mother utilized the guardian ad litem to negotiate an agreement on her behalf. And so the Department of Health and Human Services doesn't want people to feel that guardians ad litem have been imposed on them against their will. The Department of Health and Human Services wants people to have an opportunity to tell someone like Judge Dufour at the Jeopardy hearing if they don't like what's happening.
Can I ask you, I think you just said, if the mother here acquiesced ex post facto to the agreement that was made, is that what happened here? Are you arguing that's what happened here?
That's what it looks like to me. It looks like a manner of ratification.
Is that an argument you're making why we should affirm?
I think it is. That is what it appears to me. And,
But isn't that getting the cart before the horse? You say that she's acquiesced, but she's been presented with a situation where she was not given notice of the initial proceeding to appoint the 17B guardian. And now she comes to the Jeopardy hearing, at which point that fait accompli has already taken place, and she has no input, and she has to deal with this situation on the fly, so to speak.
I hear where you're coming from, Justice Lawrence. I would also like to note she's flanked at that moment in time by this phalanx of professionals that she's assembled. She retained an attorney who was there with her. She had her court-appointed attorney there with her. She had her 17B guardian ad litem fiduciary there with her, who she directed to negotiate an agreement on her behalf.
Can I clarify? The attorney and guardian ad litem felt that this agreement was in her best interest. And I think, correct me if I'm wrong, it's because it would avoid a finding of abandonment, it would avoid a finding that child was involuntarily taken. And I guess there was no jeopardy hearing? Was there a jeopardy finding here?
There was. There has to be. There has to be. And so in 2024, in front of Judge Dufour, she agreed to a jeopardy order.
Okay. So why? So the whole benefit then, so if it went the distance and the TPR issued, there would be, based upon a finding of abandonment, which is an aggravating factor, and a finding that there had been a previous finding of jeopardy and involuntary taking of the child. So what is the benefit in having an agreement so those things don't happen? I'm just trying to understand the motivation on the part of the guardian ad litem and the attorneys.
At the termination stage, when they had the empty chair next to them, I think they were, the Department of Health and Human Services had witnesses and evidence marshaled and ready to go.
Right.
And so you can see in the record that they appeared to see the writing on the wall.
The
And so-
advantage of a consent is that it cannot thereafter be used, should there be another child in another proceeding. It cannot be used as an involuntary termination would be the predicate for a future case, an aggravating factor in a future case, and a consent cannot be used as an aggravating factor in a future case. Is that the basic?
Yes, Your Honor, thank
Did
you.
you have other children?
In this record, we have mention of an older child. There's always the possibility for future younger children. That could be part of the rationale. I think in this record, you see an attorney and a guardian ad litem playing the hand they were dealt. They're at counsel table without a client. They have opposing counsel saying that they're ready to go. They know they can't argue that there wasn't good service of process. This case also exists in another lineage with cases like In Re Children of KCS out of Waterville, where we had, strong merited critique.
So my question to Attorney Kilgore, when she returns, is this sounds like this was a pretty plausible and rational action taken by the attorneys. If there may have been a due process problem in the meantime, that this was still a very prudent thing for them to have done under the circumstances with an absent client.
I think that's right, and I think I know something that would be important for this court to articulate if it is to affirm the judgment under appeal. And what that articulation would consist of would be instructions for what should happen if someone has had a 17B guardian ad litem appointed for them and they're not satisfied with that arrangement, or has become aware that one has been requested and they don't think one should be granted.
Well, but
And-
isn't it, I'm going to back you up on that. I mean, whether it's a finding of competency in the criminal cases, whether it's a finding of competency under the probate court, we don't seem to have, cases under 17B, but let me suggest to you that there are federal cases about appointment of a guardian, whether it's the Fifth Circuit, there's also one from the Third Circuit I'm looking at, all of which say before a guardian ad litem under Rule 17 can be appointed, there must be some kind of evidentiary hearing. And in fact, the Third Circuit specifically says anecdotal information, layperson opinions do not constitute appropriate verifiable evidence upon which to appoint a guardian. That didn't happen here. And putting aside all the reasons why you're saying it shouldn't be unwound, and I understand why you're going, but I guess I'm really struggling to understand why you think that it's okay to just walk in and say, Judge, I think my client should have a 17B guardian without actually hearing any evidence. And again, we can talk about what shape that takes, but at least some kind of report saying, this person can't handle their own affairs. No evidence, no record notice to the actual client as opposed to the attorney. And remember, in this situation, that would have to be different. And no actual determination based on any evidence by a judge that the person is incompetent to handle their own affairs. I mean, are you really suggesting that's okay? This is the part I'm not understanding.
No, and I'm glad you framed it that way. I think I'm going to take another attempt at articulating what I'm trying to say. What happened in August of 2023 isn't the best way for things to happen. It's not the way things should happen in the future. That doesn't mean that the judgment under appeal should be overturned.
And I understand your argument on that. I just, what I wasn't getting is you seem to be defending the process that was used here, and I'm trying to understand why you think it's okay.
I have no interest in saying that is...
So, Mr. Humphrey, let me ask you a question that might be kind of radical. Why is the department opposing this appeal? I mean, when the appeal was filed after the termination order, you've expressed some concerns about the adequacy of the process that led to the appointment of the 17B guardian. All of that may infect what happened later. So why isn't the department just allowing everybody to cut to the chase? The case has been on appeal now since, the termination hearing was last August, 6, 7, 8 months ago. And wouldn't it have been better in the child's better interests for the department just to acknowledge that there were problems with the appointment and then maybe redo the termination hearing itself? I mean, a lot of time could have been saved, and the mother's concerns, which are legitimate, could have been addressed in a meaningful way.
No, from a realpolitik perspective, I follow you, Justice Jayme. There's also the principle of the matter, and here's what I want to say about that. This is why I brought up In Re AM earlier. I think there's a really structured framework that this court has already long ago laid down for how to proceed if someone who's been served doesn't attend their termination hearing.
But isn't one of the problems here is because it went off the rails in the beginning, even the attorneys didn't really know who their client was. And at one point, the judge said, well, you have 2 clients, which cannot be. You cannot have 2 clients disagreeing with themselves. They didn't know what they were supposed to do. And didn't that get reflected in the record?
Perhaps to some extent. My bottom line is this. At the jeopardy stage, the mother, if she had an issue, should have responded to Judge Dufour. At the termination stage, Justice Jayme, the mother, if she had an issue, should have attended court and said so. Thank you.
And don't run away, because I'm going to use my prerogative and ask you another question. One of the things that I noted at the jeopardy stage and at other stages in this case is that the department was negotiating with the attorney who was appointed as the guardian ad litem as opposed to the attorney representing the mother. Is that appropriate? I mean, I understand the guardian ad litem happened to be an attorney, but she was not an attorney representing the litigant. She stood in the shoes of the litigant. Is it appropriate for the department to be negotiating directly with her as opposed to the attorney representing the litigant?
I think on this record, what I see is people deferring to the mother's direction at the jeopardy stage, that she seemed to have identified guardian ad litem Hatch as the savviest professional.
Isn't that essentially negotiating with the mother pro se is my point?
Well, you know,
If the guardian weren't an attorney, I understand it. She's an experienced attorney. I get that.
no, certainly, it's a point well taken. I think it underlines the importance of communication. If someone acting in good faith is communicating with the wrong person, then someone else who notices that just needs to let them know, and it'll be corrected.
Food for thought.
That's right, thank you.
Thank you. Attorney Gill.
So I do want to address one thing that has come up, Your Honors, which is why didn't Mindy address the court at jeopardy? And I think that you can't have it both ways. Mindy had been declared incompetent. Was it still her ability to actually address the court? Did she actually understand what was going on? If she was actually determined correctly to be incompetent, then doesn't it follow that she doesn't understand that at jeopardy she had some sort of opportunity to contest that? You can't have it both ways. And also, the attorney that was representing her at jeopardy was the same one that had her appointed a 17B guardian behind closed doors. Why is she now supposed to trust that person? Why is that person now going to change his strategy or his way and actually then challenge what he's already done?
Well, in fact, she had her own attorney. The attorney she'd retained was,
She attempted to.
attempted to have the attorney she retained there. Someone else stood in that person's shoes, correct? So it wasn't just the appointed attorney.
Correct, but again, was she incompetent or could she hire her own attorney? Again, I think that these things continued to come up all the way through the case, and you can't have it both ways. And so that's why this has to be wound back all the way to the beginning.
So I guess that's your response then, am I right, to the department's argument that she ratified at least what had happened up until the jeopardy hearing?
Exactly, and additionally, Mindy saw at every turn that no one cared. Not her attorney, not her 17B guardian, and not the judge. No one cared what Mindy thought. At what point is Mindy supposed to just take that and understand that she is supposed to sit there and be quiet? Because I know that most reasonable people would think that. No one cared about what Mindy thought. And that's just a travesty of justice. She deserved due process, and she was denied due process at every turn here. And so does it take a lot to unwind a child protective case 2.5 years back? Absolutely. Is that what we ever want to do? No. But are we really okay with the process that was provided to this parent? Is that really what we're all going to stand here and say was acceptable? That we trust this process? Because I can't tell you that I trust the process that was provided to this parent. Thank you.
Thank you. As is our usual practice in this matter, counsel, thank you. We will be taking the matter under advisement, issuing a written decision in due course. With that, we'll be in recess on this matter.
All rise.
seated. Is this you so far?
It's a spare. if you need it.
The matter before the court is Cumberland 25-421, Peter Murray et al. Versus the City of Portland et al. I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by audio and by video. I would ask that before we do the argument, that counsel introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Michael Traster for appellants Peter Murray et al.
Amy McNally for Appellee City of Portland.
Natalie Burns for Appellee 37 Montreal LLC.
Thank you. And Attorney Tracer, if you're ready to proceed, we'd be happy to hear your argument.
Yes, thank you, Your Honor, and good morning. May it please the court. I am Michael Traster. I represent the appellants Peter Murray et al. In this appeal. All of my clients are property owners in the Munjoy Hill neighborhood here in Portland's East End, and are neighbors to and live in close proximity to the proposed condominium development, which is the subject of this morning's argument and appeal.
Counsel, I see that you decided to let the green light come on right away. I have a question. Basically, according to the briefs, the ordinance has since been amended to, A, specifically exclude retaining walls from the definition of the setback, and also to define the average grade, essentially as the height measurement taken from foundation where it meets grade after construction. In other words, construing those terms exactly the way you don't want them construed. So as a practical matter, if we were to vacate, if we were to agree with you that it was a strained interpretation, shall we say, and vacate, what happens? I mean, can't Montreal just simply reapply and then the new ordinance would be clear?
Yes, Your Honor, they would need to reapply and go through the review and approval process in front of the planning board, starting anew. In terms of the result, perhaps potentially that could cure, the subsequent amendments to the ordinance could cure the height issue, but we do not believe it would cure the setback issue, because as set forth in our briefs, we don't believe the exterior walls, which are integrated as part of the condominium structure, in fact constitute retaining walls, and therefore would not be within the meaning of the amended ordinance.
Wasn't retaining walls your phrase to begin with?
No, Your Honor, we dispute that these are retaining walls. We contend that these are essentially exterior walls. They're made of concrete. They're 11 to 14 feet high on each side.
But are they attached to the structure?
They are attached, yes, Your Honor. I would contend that they are, because when you review the architecture and design plans for the proposed development, you will see that the exterior walls, what the city and the developer would like to characterize as retaining walls, are actually connected, proposed to be connected to, for lack of a better term, the main building, and improved with stone patios. So it's all one integrated building.
When you say connected, you mean connected by proximity and walkways, or whether it's actually built into the structure?
Connected by the patios that will be built.
Isn't it basically wall, fill, and then on the top of the fill is going to be patio?
Correct,
and then
Your
the
Honor.
building, right?
Exactly, Your Honor. And so we would submit to the court that no matter what one thinks of these exterior walls, and no matter how one would like to characterize them, the fact that there will be patio installed within the setback area, we think is dispositive on the question of the setback, because certainly a patio or a deck, and there's certainly plenty of precedent from this court.
But are you arguing that the patio itself is part of a member of the retaining wall?
No, we're not, Your Honor.
Okay.
We're arguing that the walls themselves are comprised of more than one member. For example, footings that they will need to be secured to on the ground, and there are also multiple sides to this wall.
So can you give me an example of a retaining wall that is not a structure under this definition?
Under the definition
of structure?
Your Honor, under the definition that applies to this project?
Yes.
a retaining wall is a structure, we would contend. So our position, Your Honor,
Right,
is
and that's
that
what I'm asking, because a structure is defined as something that has more than one member.
Correct.
So in other words, can you give me an example of a retaining wall that is not a structure?
I
You're
cannot.
basically, and that's the point. So you're basically you're defining out into oblivion any kind of retaining wall that would have to comply with
Our
setback.
position, Your Honor, is that under the definition of structure, which applies to this project and which would invoke a setback requirement, any retaining wall, and certainly this retaining wall, there could be examples, Your
And that's
Honor.
my point. In other words, there could never be a retaining wall within the setback, based on the way you read.
Based on how we read that, which we would submit, Your Honor, is exactly why the city has subsequently needed to amend its ordinance to provide for that. Because, again, under the, well, I'll call it the original definition applies to this project, it would be a structure.
You confused me, though, on that point. To the extent that any retaining wall is going to have more than one member, how does the modification of the ordinance make a difference? You're suggesting that any retaining wall is going to have more than one member, as I'm understanding your argument.
Yes, but the amended ordinance would exempt that, as I understand the amendment. So that retaining walls of more than one member, Your Honor, under the new definition, as under the amended ordinance.
Regardless of having more than one member is what you're saying.
Right.
Retaining walls are exempt, period, end of story, full stop.
That's my understanding of the amendment.
But your position is, as a factual matter, these are not retaining walls, so that amendment would not cure the problem?
Yes.
Okay.
Correct, Your Honor.
And so to what extent do we defer to the board's findings about the nature of these structures here?
Well, I think that would involve a finding of fact for which there would be some deference, but we would submit that it would be a clearly erroneous finding based on these walls and the particular design of the structure to find that these exterior facades as high as 14 feet tall, which aren't retaining any natural earth, by the way, they are going to be installed. Then there will be the inner foundation of the building and the proposal of the developers to fill that gap, which I believe is about 6 to 8 feet wide, with dirt. And then on top of that, construct a patio amenity surrounding the condominium building. And so again, I think once you get into the fact that there's going to be a deck or patio within the setback, that's just an additional reason why this project violates the setback
So it's a matter of
requirement.
interpretation in the eye of the beholder, I suppose?
It's not in the eye of the beholder. We must construe the ordinance reasonably, Your Honor.
This patio doesn't attach anything. It just sits on top of dirt, which is between two things.
Well, I think this patio would be affixed to the ground. We're going to be installing stones, attaching it. It's going to be attached to both the inner foundation wall and the outer facade,
So
et
you say if
cetera.
there's a finding of fact, there's deference, as Justice Lopez pointed out, to the board can interpret its own ordinance, right? We give deference to that interpretation.
I disagree with that, Your Honor. I think that interpretation of the ordinance is a question of law for which there is no deference by this court unless there's significant fact-finding associated with it.
Let me ask you, as long as we have some time, we're I was going to say diving into the dirt here, but that's probably not the right metaphor here. We're diving into the nuts and bolts here. Let's talk about height for just a moment.
Yes.
And is it wrong for the planning board to use past practice, past interpretations in determining what the ordinance means under these circumstances?
It is wrong, Your Honor.
And why is that?
Because past interpretations of other unrelated projects, we don't know the particulars of those projects. We don't know what ordinance criteria or terms may have been applied to those projects
But
at the
in an
time.
administrative setting, we've certainly said that, if an agency is going to change how they interpret something or what their practice, you can look to past practice as to how something has been interpreted.
But it still has to be correct as a matter of law, Your Honor. And here we would submit that
So would the board in this instance do a plain language interpretation of the board make a plain meaning interpretation of the ordinance in terms of discerning?
I think that the board not only can, but it should.
Well, it did. in this instance, in the final order that they issued, correct?
It made an interpretation, which we would submit to the court, was incorrect as a matter of law. The language that applies in the ordinance to the question at hand, and I believe it's in section 1447 of the ordinance, building height of, quote, the vertical measurement from grade or the pre-development grade on the islands to the highest point of the roof beams.
And I understand your interpretation, but isn't there some, this isn't in a vacuum. I mean, the board interpreted grade as being in contrast to pre-development grade, and isn't that really quite supported by that language?
No, Your Honor, we would disagree with that. We don't think the fact that there is a special rule that applies to islands and the special circumstances out on the islands.
I know you don't think it is,
But by reference to pre-development grade would mean that the rest of the city is somehow relieved of the ordinary and common meaning of grade, and especially when that's construed reasonably in light of the purposes of the ordinance.
Can I push you to a different issue? And this is really going back pretty basic. The definition of structure, anything constructed or erected of more than one member.
Yes.
What does more than one member mean?
We would submit, Your Honor, that the plain and ordinary meaning of member would be a part, a component, or a piece of
So
the
if
structure.
I place 2 rocks, that's more than one member?
It potentially could be if it's affixed to the ground.
Well, then why not just say if it's more than one piece or more than one item? I mean, doesn't member have a different meaning in terms of in construction?
I believe the meaning is as I just articulated, Your Honor. That member means a part or a component of. If I took a post and
But doesn't that then have to mean 2 different components or parts, as opposed to, like I say, the fact that it's more than one rock in a wall is not really the determining factor, is it?
It would need to be, again, more than one part. And I think with these walls that we're talking about, we do have more than one part.
So
we have 3 to 4 sides of it. We have footings. These walls are definitely comprised of more than one part.
But what about a picket fence?
A picket fence, under the original definition of structure, we would submit is a structure.
Okay, and so what do we do with I think there was some testimony from maybe the code enforcement officer or something like that, that basically nothing, if we were to interpret it that broadly, you'd have all sorts of setback problems all over the city, right? No one could put fences on the border of their property. I mean, so isn't that sort of illogical, or we're supposed to avoid sort of absurd results when we're interpreting ordinances?
Yes, the court is certainly to avoid absurd results, but we would submit that incorrect interpretation of the ordinance as a matter of law is not an absurd result. In other words, if it's incorrect as a matter of law, the appellants are entitled to have that reversed on appeal. In terms of the consequences, just as the city's done with the setback, and I believe they did with the height as well, they've now amended their ordinance, so we're not going to have those results going forward. They have cured that.
Thank you.
Does the court have any other questions for me?
No, not at this time. Thank you.
Good morning, and may it please the court. It was just about 3 years ago that this matter was last before this court, and since that court's remand order, as the court's aware, the planning board has held 3 comprehensive public hearings on this matter to review the issues raised by the appellants. And as the court alluded to in Attorney Traster's argument, the city has since amended its land use ordinance to clarify any of these ambiguities that have been raised by the appellants. The updated record in front of the court shows that the planning board remains unequivocal in its approval of this project, and it's bolstered by written findings and conclusions that are thorough, reasonable, and more than sufficient for judicial review. There's certainly no mystery as to why and how the board reached its conclusions that it did. The city's certain that the court will find no error in the board's legal interpretations, and there's more than sufficient evidence in the record to support the board's findings of fact and conclusions. The city would ask that this court, affirm the planning board's approval. I'd waive the rest of my protected time and take questions.
Well, I'm going to ask you the same question I asked Attorney Tracer. What does it mean to have a structure defined as something constructed or erected of more than one member? What is that mean, more than one member?
Your Honor, I'm not certain I'm going to have a great answer for the court as far as what that means, and the board in this instance did not reach that question because it took the plain meaning of the ordinance, but in the context of the ordinance as a whole, and applied the dimensional standards that were relevant to the Montjoy Hill overlay district, and determined based on that language with regard to setbacks that those setbacks requirements were measured vis-a-vis buildings or structures or accessory structures.
It doesn't really say that.
It says it insofar as the context for the basis for those measurements are vis-a-vis buildings, structures, buildings or accessory structures, which are generally houses, sheds, things like that.
Well, the fact that the municipality, the city, has amended the ordinances to make all this more clear, doesn't that really work in favor of the neighbors here to demonstrate that, in fact, the ordinances should have been implemented to prevent this project?
I think it's certainly prudent on the city council to adopt a legislative fix for these issues. I think the testimony in the record was that
no fix would have been necessary if the city were correct in its interpretation to begin with.
Well, I think the interpretation that the board adopted is consistent with the legislative fix that the city council made. So the city council's fix with regard to...
So why was a fix needed if the board was correct to begin with?
To clarify for members of the public, to avoid challenges in the future, I'd imagine, to make it unequivocal for applicants or abutters for future applications.
Can I ask you a question about the historic district consideration, the factor here?
Sure. My colleague, Attorney Burns, is more prepared to speak to that, but I can certainly answer questions.
All right. Well, as an outsider to Ms. Burns' interest, I'm looking at the definition of compatibility and what it says, and I'm looking at page 68 at the top of the appendix. And it says compatibility, and I'm sort of paraphrasing here, compatibility is a design that respects the established building patterns and visual characteristics, but is also a distinct product of its own time. Tell me what that means. How is that an enforceable or a meaningful standard?
Well, and I think the board, I think that both of the memorandums from 2021 and from 2025 do a good job of identifying the major characteristics of the district, whether it, and particularly with buildings of around the same size. So triple-decker apartment complexes, they often have a flat roof. They rise sheer from the ground, so they're flat and they have certain.
But what does the word respect mean, especially when the new building, the new project, is allowed to have a distinct, to be a distinct product of its own time?
Well, I think
it has to be kind of similar, but it can be different, you know?
Correct. I think it's a great question, and I think in the memo, again, the two memos, the similarities that are referenced are the stacked balconies, the arrangements of the windows, the entryways. All of those things have similarities, but maybe the materials or some of the
maybe it's brick or it's clapboard, but it's not going to be adobe.
Correct. Right. Like similar but distinct in some ways. So.
But what does its own time mean?
Well,
is it IKEA look or something like that, or some millennial favorite? I have no idea what that means.
Well, I think modern materials. I think maybe more environmentally savvy materials or things like that. That's what I can think about.
So this is the 21st century. Maybe it'll look like the Jetsons' house with big plexiglass going around.
I'm not sure that would respect the character-defining elements of the district in that way. That might veer awry of those character-defining elements that were identified in those memos.
Can I take you back to this definition of structure?
Sure.
Because you have argued that there's a sort of a different setback requirement for the Montjoy Hill district, and Chief Justice Stanfield sort of started talking about this before, and I want to follow up. I'm looking at Appendix 52. It does reference buildings vis-a-vis the setback, but it's still in a box that's defined as minimum side yard setback. And then the ordinance defines setbacks relevant to structure. So I guess I'm a little bit puzzled by this argument that we sort of don't look at that definition in the context here.
Correct, and I think the board laid this out in its findings. It did an analysis that those two definitions certainly do exist, but they're not in isolation. They're both with an R6 zones dimensional standards, which again reference buildings and accessory structures. They're with these dimensional standards that Your Honor's talking about. And we also have to think about the ordinance as a whole and how it's applied in practice, right? And so if every single structure, and I think some of Your Honors were alluding to this, if every single structure, I'm thinking a mailbox, if that was subject to a 15, 20, 30-foot setback, USPS would have trouble delivering mail. So these are practical matters where, in order to avoid an absurd result.
But looking at those, it really uses buildings just to define in other words, buildings of a certain height require setbacks of a certain size. I mean, it doesn't say anything about the setback being measured from the building there.
Not explicitly, Your Honor, but it makes practical sense that a setback would be distinct for buildings of different heights.
But is the argument that we should essentially disregard the definition of setback for this particular project because of where it's located?
Not disregard, Your Honor, but not read it in isolation. Again, as the board did, the board acknowledged those two definitions, but then looked to the dimensional standards, which are zone specific, which are really the crux of the land use code that the board is tasked with applying.
I guess my problem is this. I can look at those. I'm looking at them right now on Appendix 52, 53. But setback is defined as required distance and land resulting therefrom between a street line and the closest possible line of conforming structure. And I don't see anything in the overlay at 52, 53 that changes or adds to that. It's just telling you what the setback is with particular building heights. It doesn't change the definition of what a setback is. There's nothing in there that even tweaks it at all, as far as I can see.
It doesn't change the definition, Your Honor, but I think as the board noted in its deliberations and in its written findings, based on the totality of the circumstances and the evidence that they were presented before it, that both historically and as a matter of pattern, these setbacks are almost exclusively applied to buildings or accessory structures.
And is that really what it comes down to, is the essentially by practice, by historic practicality, et cetera, regardless of the language?
I don't think it's certainly not regardless of the language, Your Honor, but I do think it all taken together, again, the ordinance as a whole, the evidence in front of the board at that time, the past practice, the practicality, and to avoid absurd results in the city, particularly in a dense part of the city on the peninsula, I think all of that taken together is reasonable.
I take it you'd be happier arguing your position based on the new ordinance?
Absolutely, Your Honor, and I think as Your Honors alluded to, the new language is very with regard to setbacks. The definition includes a caveat that says setbacks do not apply to fences, retaining walls, raised gardens, beds, or similar structures.
Well, Section 1447 on height could use. I don't know if that was.
That was also amended, Your Honor.
Okay.
The height building of includes now average grade. Average grade is now a defined term in the new ordinance, and it both includes post-construction measurement, and it includes a measurement of no less than 3 feet or no more than 10 feet around the interval of the building.
That would provide a lot of clarity.
It adds a lot of clarity, Your Honor.
Are we governed by the existing?
Under this project has pending proceedings under the 2019 version of the code.
So trying to parse that, we like plain language if we can find it, but I'm having a hard time finding it here. It's the building height is the vertical measurement from the grade, comma, or the pre-development grade on the islands, comma, to the highest point. Does the ordinance tell us anything about why there's a different starting point on island or off?
It doesn't, Your Honor. I can offer some speculation that there's less appetite for fill on the island than maybe on the mainland. But there's not necessarily any policy or purpose language.
So why would we default to post-construction height?
Where if you not doing so would conflate pre-development which is a defined term, with grade, which is a distinct term, and has a distinct application under that definition, because grade, as undefined as it is, applies to the mainland, and then pre-development grade applies exclusively on the island. So as the board delineated in its findings, they must be distinct. And there's one post makes sense. The definition of grade, I think even in Attorney Tracer's brief, always, if I may, the definition of grade, even in the Webster's Dictionary, references a building, so it makes practical sense that the grade post-construction vis-a-vis the building would be the applicable standard.
Thank you.
Thank you, Your Honor.
Attorney Burns, I take it you were going to address the historic.
That's correct, Your Honor.
Overlay.
May it please the court. In addition to the other two standards that the court has noted have been repealed under the new version of the city's land use code, this standard also has been repealed. But we are here under the prior ordinance, and the court did ask, well, should my client just start over again? And I will say my client has been in process with this particular design since prior to the pandemic. My client has, as you can appreciate, a significant investment in this project, and there are some other changes to the ordinance that have occurred as part of the recode that would require a complete redesign of the project. And so for that reason, my client chooses to proceed forward under the prior planning board approvals and ask the court to affirm that decision. As to the historic preservation, there was a question about what some of that means, and I will tell you that I'm not sure anybody knows what it means. I can tell you where it came from. It came from the National Park Service, which provides historic preservation design requirements that municipalities that adopt historic preservation ordinances are supposed to adopt those requirements, and that is one of them, being a product of its own time while being respectful. I'm not sure it says respectful.
Well, if nobody knows what that standard means, how can you argue that the project satisfies that unknowable
Your
standard?
Honor, it is a design standard. It's important to note that it is this particular standard. This, as the court knows, this project is not in the historic district, but it is subject to this review because it's within 100 feet of the historic district. And so because of that, we do have to look at this standard, but we look at it as a design standard. It is not a zoning standard. It does not override
But
other
it's a standard
provisions.
that's still, it's a criterion that still needs to be satisfied.
It does need to be satisfied,
And if nobody knows
Your
what it
Honor.
means, how can you satisfy it?
Well, because this court has said in past decisions that where things are in the nature of a site plan or an environmental review ordinance, that it is not subject to the same type of standards that are applied to zoning standards. In the review of zoning standards, the court will say something is not a sufficient standard to be applied. But in the context of design and environmental issues, the court has given municipalities and the state much more leeway in what they do. And so it becomes a matter of looking at what has happened in the past. I think Portland in particular, the Historic Preservation Ordinance was adopted in the early 1990s because there was such a great deal of concern about buildings that were lost over a period of time. But in addition to buildings being lost, you do want things to be consistent, compatible, and what that means is that you don't have a completely, I think someone did say, can you have a Jetsons house? And no, that would not meet the test. And, you know,
How do you know?
Well, I guess it would depend upon the design of the Jetsons house, Your Honor.
Isn't it all in the eye of the beholder, though? This is...
Well, remember that the ordinance says that what the historic preservation manager is supposed to guide the planning board in is looking at the context of the historic district in the immediate vicinity, not within 100 feet, as has been argued in plaintiff's brief, within the immediate vicinity, and it talks about what elements you're supposed to be looking at. And so if you look at the historic district designation itself for guidance with that. Thank you, Your Honor. Just in time.
Thank you. Attorney Tracer?
Yes, just, of course, briefly, Your Honor. With respect to the historic preservation report and standards, we would submit to the court that this is the Jetson House, that this project is completely incompatible with the major defining elements of the historic district. And I think it's critical to understand that the ordinance standard is not anywhere in the historic district as defined in the code, but in the immediate vicinity, the section of the district in the immediate vicinity of the project at hand.
But that's not necessarily limited to the very bordering houses.
No, but it's certainly limited to the immediate across the street, 1 block over. We would submit that the report that was relied on by the planning board went far afield of the immediate vicinity in referring to things like triple deckers and other things that may in fact be on the hill, may be in the historic preservation district, are not in fact in the immediate vicinity of this project. There is nothing in the immediate vicinity of this project that is anything like this structure, this building, this condominium.
Depending on how you define immediate vicinity.
Right, it is.
Isn't a change in the posture of this case from when it was first before us? At that point, there hadn't been that evaluation done, and that was part of the issue that required it to be remanded.
That is correct, Your Honor. We still think, as is explained in our brief, there are multiple fatal defects in the process that was undertaken with respect to the historical preservation review, one of which, one of the most important of which is the board actually voted to approve the project before they ever received the report. The report came after, and clearly...
But they now have a report.
They now have a report, but it came after they...
Again, right? They voted again after they got the report.
They did, Your Honor. But...
Doesn't that cure the problem?
We would say no. The process should be, as a matter of common sense and logic, that as the board is reviewing it and before they vote as to whether the project should be approved in general to any specific standard, they needed to have this report to inform their decision-making on all criteria.
So your position was that it was impossible for them to cure that procedural defect?
It is impossible to cure this particular defect with the report coming after the board's review and vote.
But they re-reviewed. I mean...
They did not re-review, Your Honor. They reviewed that particular criteria in mandate.
And determined it didn't change how they were...
Correct, Your Honor. The last thing I would say, Your Honor, is structure means structure. Structure is clearly defined in the ordinance as it applies to this project, and the fact that the city has had to cure and amend its ordinance, we think is pretty darn clear evidence that the city's interpretation of its ordinance as to this project was incorrect as a matter of law. Thank you.
Thank you. Thank you, counsel, for your argument here this morning. As is our usual practice, we'll take the matter under advisement, issue a written decision in due course. And with that, we are in recess for the morning.